Aloha. In this video, I'm going to walk you through one of the key rules of the Hawaii Rules of Professional Conduct, or the HRPC, as people usually call it. This important rule is Rule 1.6, Confidentiality of Information. And I want to draw your attention to the fact that you see some regular writing in the left-hand column, and then in part of the right-hand column you see something italicized that says comments. That's because each of the rules is modified or explained in more detail by the comments. So I'm going to show you not only the rule, but some of the comments and how they're used to expand the definitions of the rule. Because it won't be enough for you to just know the rule, you've got to be able to apply the relevant expanded comments as well. So let's start with Rule 1.6, Paragraph A. A reads, "A lawyer shall not reveal confidential information relating to the representation of a client unless the client consents after consultation, the disclosure is impliedly authorized in order to carry out the representation, or as stated in paragraph B or C." Let's take this section apart. The whole rule, or the point of the rule, appears in the first two sentences. A lawyer shall not reveal confidential information relating to the representation of a client. So what information can't be revealed? Confidential information. And in what context? Relating to the representation of a client. This means anything that the client mentions in the course of seeking representation, not just the specific divorce case the client might be talking about to the attorney, but also any information about the business that would necessarily have to be revealed in order to discuss the sharing of assets in a divorce case. So the initial statement is quite broad, but then it's immediately followed by three exceptions. The first one says, unless the client consents after consultation. That means the client would not only have to agree to let the lawyer share that information, but the client is entitled to consult with another lawyer, a different lawyer, to say, look, what are the impacts of me revealing this information that otherwise would be protected by the confidentiality rule. So the client consents after consultation. The second one is the disclosure is impliedly authorized in order to carry out the representation. This means the disclosure has to be done. It's part of the whole reason that the attorney was consulted in the first place. For example, in a divorce case, the client is supposed to share all of their assets, all that information relating to how they got property, real property, during the marriage and before the marriage with the attorney. The attorney can't gratuitously go around and tell people that, but the attorney can disclose that in coming up with the various documents that are going to be required by the court, in which the client is supposed to honestly share the extent of his or her assets. So if the disclosure is implied by the representation, then it's not a violation if the attorney shares that information in court documents, for example. The third exemption is actually quite extensive because it says, or as stated in paragraph B or C. So you know there's going to be at least two other confidentiality exclusions, and we have to look at B, and just from what we can see on the screen, B is pretty long. So let's center paragraph B on the screen and go through it one part at a time. Just notice the structure, though, of B. You'll see that it says B and then 1, 2, 3, 4, 5. This structure, to the legal mind, says everything in B is going to then be part of 1, part of 2, part of 3. It helps keep the document shorter without repeating it. So B starts off with saying, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. And then the first exception under that is to prevent a client from committing a criminal or fraudulent act that the lawyer reasonably believes is likely to result in death or substantial bodily harm or in substantial injury to the financial interests or property of another. Let's take a look at the words criminal or fraudulent act. A criminal act is something that is a crime. Fraud, however, implies that it's a civil wrong. So this exception is if the client is going to do something that's either a criminal wrong or a civil wrong. It's not one or the other, it's both. And the lawyer has to reasonably believe that this act that the client is going to prevent, this future action, is likely to result in one of three consequences: death, substantial bodily harm, or substantial injury to the financial interests or property of another person. When would this come into play? Well, sometimes an attorney might be used as a sounding board for a client about things that they're thinking about doing in the future. Let's say that an attorney represents a client who's going to trial, and the client comments that there's just one pesky witness, but not to worry because he won't be talking to anybody after tomorrow. This sounds like an implied threat on that witness's life, and that would be a criminal act likely to result in death of another, and that would free the attorney to share that potential issue with local law enforcement. So before we go on to 2, let's just remember that this one has to do with future bad acts of the client. Paragraph 2 says, to rectify the consequences of a client's act, which the lawyer reasonably believes to have been criminal or fraudulent, and in the furtherance of which the lawyer's services had been used. This is a long sentence, but we're going to unpack that. And really, the parsing of small bits of any of these comments is going to be key to your understanding these on your own. So, to rectify means to make right. So this has to do with the consequences of an act that's been done in the past. So, a lawyer may reveal information necessary to rectify the consequences of a client's act, which the lawyer reasonably believes to have been criminal or fraudulent, so again, a crime or a tort, something on the civil side, and don't forget the and, in the furtherance of which the lawyer's services had been used. This last sentence means the lawyer's services, the lawyer's advice, the lawyer's documents, were used to do this wrong thing. And this last phrase is really a key to the whole paragraph, because normally the rule is that a lawyer must keep confidential everything that has happened in the past. We saw paragraph 1 gives an exemption for future actions, but this has to do with something that happened in the past, but only if the client improperly used the attorney's services to do that bad thing. For example, let's say the attorney is a tax lawyer, and he is advising his client on ways to legally shield his income from taxes. And the client asks, well, what about putting it in a Swiss bank account? I hear that that's a certain mechanism. And the lawyer very earnestly says, oh no, that would be illegal because you'd have to do A, B, and C, and that would be a violation of U.S. tax laws. So the client takes the attorney's statement about why he shouldn't do this and promptly goes out and does A, B, and C and hides his assets in a Swiss bank account. And then he comes back to the lawyer and says, thanks, pal, I took your advice and now all of my assets are hidden. In this case, it would come directly under 2 because the lawyer's services were used improperly. The lawyer didn't mean to give advice on how to break the law. He was trying to avoid that. But the client took the advice and hid assets from the United States government, which is a crime. So in that instance, the lawyer could break the confidentiality rule. Now let's take a look at number 3. This is a new addition to the law after the 2014 revision. This says a lawyer may reveal information to secure legal advice about the lawyer's compliance with these rules. A lawyer can ask the Office of Disciplinary Counsel for advice on how to handle issues that are in an ethic gray area. However, until we had this new section, the lawyer was actually technically in violation of Rule 1.6 if the ODC could tell who the client really was. And sometimes a client is so prominent in the community, there's just no way you could use a hypothetical to disguise who the client's identity really is. But this new exception says if a lawyer needs to go to the Office of Disciplinary Counsel and get some ethics advice, the lawyer can do that and will not violate 1.6. That's pretty straightforward. Now let's take a look at paragraph 4. Paragraph 4 has 3 parts, but they're all related to the same theme, which is sometimes a lawyer needs to be able to protect themselves in actions involving accusations that they did something wrong in relation to the client. And a lawyer is not required to be silent on those occasions. So let's take a look at each of these 3 one at a time. The first says a lawyer may reveal information to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. For example, if the client sues the lawyer for malpractice, alleging that the lawyer gave him bad advice, the lawyer is allowed to share the confidences that he told the client in order to prove that no, he didn't give the bad advice that is alleged. The second paragraph says that you can disclose information to establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved. An example is the tax law situation that I talked about a few minutes ago. Let's say that after stashing that money in the Swiss bank account, the client is actually caught by the U.S. Department of Treasury and is being prosecuted for tax fraud. And let's say that client then turns on his attorney and says, "Oh, I'm innocent. I was only following what attorney Susan Jarowski said." If that were me, I would be entitled to defend myself by saying, "Absolutely not. I did not give my client this advice. In fact, here's the memo that I gave him that specified the exact opposite." Normally, I would not be able to share the advice I gave to my client, but in this case, I'm allowed to defend myself. Paragraph 5 looks a lot like paragraph 1, except it has to do with government attorneys and their public clients. Number 5 says, an attorney may reveal information to prevent a public official or public agency from committing a criminal or illegal act that a government lawyer reasonably believes is likely to result in harm to the public good. So this is the same kind of confidentiality exception that we saw for private lawyers applied to public lawyers. Paragraph 6 also looks similar to something we've seen before. It says a lawyer may reveal information to rectify the consequences of a public official's or public agency's act which the government lawyer reasonably believes to have been criminal or illegal and harmful to the public. Paragraph 7 is the catch-all phrase. It allows a lawyer to reveal information to the extent strictly necessary to comply with other law, fiduciary obligations, or court orders. In other words, if a court were to order an attorney to reveal certain client information, the attorney would have to comply. Paragraph C is going to look very similar to language we've already seen in B, but there are a few key differences. See if you can spot them while I read it. A lawyer shall reveal information that clearly establishes a criminal or fraudulent act of the client, in the furtherance of which the lawyer's services had been used, to the extent reasonably necessary to rectify the consequences of such act, where the act has resulted in substantial injury to the financial interests or property of another. The 3 major changes I see here are that the lawyer shall reveal information, whereas paragraph B is all about how the lawyer may reveal information. So paragraph C is stronger and imposes more of a duty on the lawyer. And what is this difference in this information? It's information that clearly establishes a criminal or fraudulent act. In the prior paragraph, paragraph B, it was the lawyer's reasonable belief, which means the lawyer might do this if the lawyer's kind of thinking it's reasonable that the client's going to do something bad. In this case, it says, without qualifiers, the lawyer shall do this if something is clearly established as a criminal or fraudulent act in which the attorney's services were used to rectify the consequences of the act. Interestingly, in the prior paragraph about the impact of the act, it was death or substantial bodily injury, and those have been dropped in favor of just saying where the act would result in substantial injury to the financial interests or property of another. It's kind of curious that it doesn't exactly track the language of paragraph B. But that is the difference between paragraph B and paragraph C. Here's another view of the whole rule. Notice how it pretty much fits onto one screen. There's a little bit more underneath for paragraph C. And I just want to skim down right now to show you how much longer the comments are in comparison to the rule. So I'm just going to click one screen of comments, 2, 3, 4, 5, 6, 7, 8. 8 screens to supplement basically one screen of text. That's why it's so important that you look at the comments when you're trying to interpret the rule. Now, you don't necessarily need to read all of the comments every time you're looking at a specific rule. The comments are usually targeted to a specific paragraph or specific language in the rule, but you do have to look at the comments that do deal with that paragraph or that language. So I'm going to go through, maybe 5 or 6 of the key comments that I think relate to Rule 1.6, and you can go through the rest on your own. So let's scroll back to the top. 4, 5, 6, 7, 8. Oh, sorry, there's the comments. And notice, as I said earlier, that the comments are going to be in italics. That's how you can tell that they're different. Comment 2 states, a fundamental principle in the client-lawyer relationship is that, in the absence of the client's consent after consultation, the lawyer must not reveal information relating to the representation. This contributes to the trust that is the hallmark of the client-lawyer relationship. The client is thereby encouraged to seek legal assistance and to communicate fully and frankly with the lawyer, even as to embarrassing or illegally damaging subject matter. The lawyer needs this information to represent the client effectively and, if necessary, to advise the client to refrain from wrongful conduct. So this comment establishes how important this ethical rule is, and so how seriously we must take any of the exceptions, because the basic rule is, unless the client says you can, you shouldn't be able to do anything about the information that's given to you. So you have to read all of these exceptions very carefully. Let's skip down to comment 4. Comment 4 agrees with the general paragraph that starts the rule, saying that paragraph A prohibits a lawyer from revealing information relating to the representation of a client. So the next sentence extends that to say, this prohibition also applies to disclosures by a lawyer that do not in themselves reveal protected information, but could reasonably lead to the discovery of such information by a third person. A lawyer's use of a hypothetical to discuss issues relating to the representation is permissible, so long as there is no reasonable likelihood that the listener will be able to ascertain the identity of the client or the situation involved. So this says not only can't you say specific information, you can only use general hypotheticals if you're sure they can't be tracked back to a specific person. For example, let me say that one of my clients, whose name I won't mention, is a very, very prominent African American. In fact, he's so prominent that he became the first president of the United States, and he's about to get a divorce from his longtime wife. Now, I don't have to tell you that I'm talking about Barack Obama, because I've given you so much information in my hypothetical that the connection is obvious. So what this is saying is you have to even be very careful of the hypothetical explanations that you might talk to other lawyers about or talk to your family and friends about, because if it can be tracked back to a specific person or situation, you have violated confidentiality. Let's go down to take a look at another comment. I'm not going to go through all of comment 8, but I want to show you how it highlights the differences between paragraphs B and C. It says, where the lawyer's information falls short of clearly establishing a criminal or fraudulent act by the client, but supports a reasonable belief by the lawyer that a criminal or fraudulent act has occurred, the discretionary disclosure, and discretionary means may, not shall, of Rule 1.6b of these rules may be applicable. However, where the lawyer's information clearly establishes the criminal or fraudulent act, the mandatory, the must disclosure, the shall disclose requirement of 1.6c may be applicable. And in the rest of the paragraph, it talks more about the differences between paragraph B and paragraph C, and you can read it on your own if you want that detail. Comment 17 provides a really good example of why comments are necessary, because it talks about something that may have come to your mind. What if you have a really scuzzy client who insists on using your lawyer's advice to do the wrong thing? Well, paragraph 17 provides that if the lawyer's services will be used by the client in materially furthering a course of criminal or fraudulent conduct in the future, the lawyer must withdraw, as stated in another section or Rule 1.16. Now we're going to take a look at 3 comments that have a very strong bearing on paralegals in a law firm. Comments 18 and 19 have to do with the duty of the attorney to keep the information confidential. And 18 says a lawyer must act competently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. And then it cites rules 1.1, 5.1, and 5.3 of these rules. And rule 5.3 has to deal with the responsibilities of paralegals. So this is saying the lawyer can't just say, in my mind it's confidential. The lawyer must act competently to make sure that everyone else in the law firm knows that they can't inadvertently or unauthorizedly disclose that information. And comment 19 backs that up by saying, when transmitting a communication that includes information relating to the representation of a client, the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. This means the lawyer must take care in faxing, making sure that the lawyer has the right fax number, making sure the lawyer has the correct email address, making sure if the lawyer is going to send something through email, the lawyer doesn't click the dreaded reply all button and release information that should have gone directly to a client to others. And now we'll take a look at one last but very important section. That comment is comment 20, former client. This states the duty of confidentiality continues after the client-lawyer relationship has terminated. Why do we have this rule? Well, think about what would happen if we didn't. This means you could entrust your lawyer with all of your secrets, your questions, your past questionable acts, as long as you hired them, and as soon as you terminated the action, for instance, in your divorce case, as soon as you terminated the divorce case, the lawyer could go to the IRS to tell them all about your questionable tax practices. They could go to your employer and say, hey, did you know he's been using the company credit card for this or that? No way. The duty of confidentiality must persist even after the client has stopped paying the lawyer money for the specific role or the specific task that the client has asked the lawyer to do. The duty of confidentiality is forever. I hope this walkthrough will make you feel more comfortable when it's your turn to read one of the Hawaii Rules of Professional Conduct. Remember to break it up into individual sections and to review the comments to see if there's any further explanation that will help you understand the scope of the rule.